Hello and welcome to our very first episode of Meet Penn's Professors. I am your host, Nicolas Scola, and today I am honored to have a truly special guest with us today, Professor Jon Smollen. Mr. Smollen is a professor in the Wharton School of Business who taught law and social values last semester, a fantastic class, and highly recommended to any students who are watching this episode today. He has extensive experience in corporate compliance, has worked as an advisor and attorney at the FTC, and served as Executive Vice President and Chief Compliance Officer for Endo International, just to name a few of his many career accomplishments. Thank you for joining us today, Professor Smollen.
Thank you for having me. I'm glad to be here, and thank you for the feedback on the class. We're always looking to improve it, so it's great to have kind of hear from students.
So in today's episode, we'll touch on a wellspring of different topics, but before we do, take us through your career up to this point.
Sure. So I graduated. Maybe I could talk a little bit about how I even arrived at going to law school. I graduated in the late 80s from Georgetown. I thought I wanted to go get a PhD in history. Spent a year working for a researcher who was a Southern historian that was looking at community structures in the South in the pre-Civil War period. Found that I didn't necessarily want to spend my whole life focused on one particular academic topic, but part of what he did was serve as an expert witness in voting rights cases. So I spent about 2 years working within the voting rights division, voting rights section of the Civil Rights Division of the Department of Justice in the late 80s, and got very interested in law and law as kind of how it can impact society. Took a little bit of a detour, although it kind of, I think, helped me in my career, and got a master's degree in international affairs, and then went to law school. I think one of the bad byproducts of all of that school was a lot of debt. So I spent a fair amount of time, or some time, working at a law firm, which, had some benefits, and I learned a lot. Clerk for a federal judge, district court judge, which was a really interesting experience. And then spent, I'd say, the first 6 or 7 years post-clerkship working for the Federal Trade Commission. Working as someone kind of a line attorney, putting together consumer protection cases, and then spent a couple of years working for a commissioner of the FTC, which was much more policy oriented. And then moved from Washington, D.C. to Philadelphia to join a company called Wyeth, where I was, Wyeth Pharmaceuticals I was the chief privacy officer. So I've been working a lot on privacy issues in government, and then started to kind of work on those issues through in a global pharmaceutical company, which was really interesting and very different than what I'd done before. Spent about 15, 16 years in pharmaceutical, and really in healthcare, because it was pharmaceuticals, consumer healthcare, medical devices, companies like Wyeth, Pfizer, Siemens, Endo, working on legal issues, regulatory issues, policy issues, and then kind of ultimately becoming a chief compliance and ethics officer at 2 different companies. Did that, always had an interest in kind of the academic world, and also kind of bridging government, academics, and different industry groups. And kind of in 2016, left industry to go on the faculty at Temple Law School and to start a center at Temple called the Center for Compliance and Ethics, which was designed to kind of help students kind of think about these careers, kind of develop kind of more rigorous academic analysis of them, and then bring kind of the dialogue between government and industry and academics into kind of an academic format. And I did that for about six years, still involved in that. And then about 2 years ago, got the opportunity to come over and teach as a lecturer in law at Wharton to undergrads. I had kind of historically taught second year and third year law students at Temple, and I felt like that would be an interesting experience. And so I've been doing that. And I've also been, for the last 5 years, serving on the board of directors of Astellas Pharmaceuticals, which is a Japanese pharmaceutical company where I sit on the US board. So a variety of things. I'm not quite sure, a lot of the pathways, there's some consistency in terms of kind of wanting to be curious about exploring kind of new areas of law, and the intersection, I'd say, between kind of emerging policy and law and emerging societal expectations. I think if I kind of think about what's driven a lot of those choices.
Thank you for sharing. And as you touched a little bit upon, you have extensive experience, obviously, in the compliance and ethics space. So could you speak a little to the importance of having a good compliance program as a corporation? And practically, how have you gone about advising multinational corporations to institute compliance teams?
Sure. I think there are obvious, and in some ways, I think sometimes people lead with the legal and risk mitigation aspects or minimizing legal risk. So I want to acknowledge those, but I want to kind of maybe focus a little bit, I think, on some of the other reasons why I think it's important for companies to have effective compliance and ethics programs. And we'll kind of talk a little bit about that distinction. But I mean, obviously, from a legal standpoint, I think as we talked about in our class, I think there's been a movement in the U.S. sentencing guidelines and kind of how the Department of Justice in the U.S. looks at kind of corporate violations. And one of the things that they're really trying to emphasize is that companies, in terms of kind of how the government may look at corporate behavior, the more they have a proactive approach to kind of preventing violations of law or violations of different standards, detecting them, responding to them, the more they're going to be favorably disposed in dealing with either a prosecutorial decision or a sentencing decision or kind of what a settlement might look like. I think it also comes up in the context legally, in terms of kind of litigation that could arise about corporate behavior, where if a company has done as much as it can to kind of put out clear standards, train its employees, monitor how employees are behaving, deal with deviations from kind of established standards of conduct, the more that's a viable defense, I think, in the context of litigation to say, yes, there was misconduct, but the misconduct wasn't intentional. The misconduct was not kind of core to what the corporation was about. So I think that's kind of the legal side of this, or risk mitigation side. I think part of it, to me, I mean, when I talk to either internally when I was at companies or to boards or management, or even I think in class, I try to put as much or more weight on kind of the reputational and kind of cultural sides of that for companies. I mean, I think good compliance and ethics programs are designed not simply to say, like, let's stop violations of law, but let's kind of try to design our business behavior around kind of emerging standards of what corporate behavior should be, or what societal expectations of what corporations should do. I think it's kind of critical for employees or customers who want to either be employed by a company, to stay with the company, and a level of employee engagement, to feel like the company is truly trying to live by a set of values. I think that's important to customers. And I think it kind of informs kind of how industries are perceived, and what the impact, and I think kind of regulators broadly, whether it's a regulator that's enforcing against you or a regulator that is kind of overall taking a look at your industry, wants to see that you're concerned about kind of how your company behaves. In some ways, I think that echoes some of the themes we talked about with stakeholder theory. I think the other kind of part of compliance programs, which I think people don't think about, but in practice, what I saw is, in some ways, I think well-designed compliance and ethics programs that really kind of have a good sense of how a business runs, kind of, what the incentives are, what kind of the incentives are driving behavior, how well the average employee understands and can do their job and understands the boundaries around their jobs, how efficient the business is. There are a lot of ways where compliance programs point out, I think, things that are kind of how to operate better as a business and how to be more effective as a business. And there are insights that a compliance program can provide management to say, not only is this about adhering to our values in the law, it's also about kind of running kind of an effective business where we understand what actually is going on in the business, because a lot of what a compliance program is attuned with is what actually is occurring in the business. Are things going the way we thought they would be going? is behavior consistent? Are third parties acting in a consistent way? So a lot of times you get insights that I think are useful to business management. And I think when you're inside a company driving a compliance program, is really important to push that point because you kind of start to embed yourself more in the business, which allows you to have a better insight as to risks in the business and to be a more credible partner with your business partners.
And as an advisor to these corporations, how do corporate compliance considerations change depending on the business that you're advising? For example, for a pharmaceutical company such as Pfizer, how would precautions that the company takes be different than a bank like Wells Fargo?
Yeah. So a couple of things before we talk about the industry side. I mean, a lot of times when I've worked with companies as an advisor, some of the kind of threshold questions are kind of, okay, where are we? Are we in an early stage of the development of the company? Is the company kind of fully developed in terms of its governance, its operational structures, its systems? So is it a very mature company with a very mature compliance program? Is it a compliance program that is kind of responding to a particular issue where maybe the program hasn't worked as effectively? So when I think about working with a company, it's trying to say like, okay, where are we situated in terms of the maturity curve and the kind of external drivers for what's going on in the company? In terms of the industry side, I'd say there are kind of distinctions and commonalities. So, things like, say, and it's interesting because when I used to teach this at Temple, and I started to use Wells Fargo as a case study, I felt like it would feel and not as a banking person, but more as a healthcare person, I felt like it would be difficult to understand. And I found there were parts of it that were very familiar. So, in terms of the distinctions, I mean, I think compliance and ethics programs are designed around the specific risks that are, inherent to the business that they're kind of in. So in a pharmaceutical company, a global pharmaceutical company, you're thinking about a different set of laws, right? So, what are the laws that regulate and inform the standards that you're going to be trying to drive into the business? So, like in a pharmaceutical company, one of the big issues is, off-label promotion or financial connections between customers and healthcare providers and your organization. Your selling model is different, so the touch points of where those risks can arise are different. And it also may be like, where are you operating? Are you only a domestic concern? Obviously, in a global pharmaceutical company, if you're operating in 75 countries, some of those countries you're operating through third parties, you need to be very concerned with a law like the Foreign Corrupt Practices Act. In the banking context, it's different, right? I mean, they're different. The way you face your regulators is different. The laws that you're applying are different. So the way you go to market, is very different, and how those risks could manifest. So there are distinctions that are based on the laws, the operations, and the footprint. The things I think that are common, when I first started teaching Wells Fargo as a case study, I mean, you have to, in any compliance and ethics program, one of the main things you're thinking about is, okay, what are the incentives that we have for employees and how do we drive that? So in the Wells Fargo case study that we talked about in our class, one of the big issues that, drove the problems there was kind of incentives that were unrealistic and too high, and that employees, in terms of kind of getting 8 accounts per customer, could never be met. That's very much like some of the concerns that you would see in a pharmaceutical company around sales targets and sales targets for prescriptions staying within the labeled indication and off label. So to me, it was kind of like, okay, that's almost, I could completely understand the issues around kind of incentives. I think some of the issues around, how this constant dynamic between centralization and decentralization in a company. So I think in all companies, I think there's this tension between, we want the business to run and that the business needs some autonomy, but we want to have oversight. How do we balance kind of empowering the business while centralizing certain functions and certain decisions in order to give oversight? That's a very common theme that I think you see in kind of, and I'm not going to speak, I don't necessarily know much about Pfizer, but I mean, in any company I've been in, that's always been a balancing concern. I think kind of, the ideas about like, what do you do to create kind of an open culture, a culture where people can raise issues? How do you get the right kinds of information flowing up to senior management and then flowing up to a board? Those are kind of common concerns that are kind of independent of the nature of the business and the nature of the risk. So those are kind of, I'd say, a set of distinctions and a set of differences that, we talked about Wells Fargo and Pfizer, but I think you kind of see those kinds of differences and commonalities in lots of different industries and companies.
And in your experience and research, have you found that the majority of violations occur as the result of lower level employees, or oftentimes is it the case that C-suite executives or upper level managers are involved in the violation?
That's hard to say consistently with a broad brush. I think that kind of similar to what we talked about when we talked about Wells Fargo, you may have kind of lower level employees kind of involved in violations, but the risk of those types of behaviors might be a logical extension of strategies or business plans that arguably, you could make the argument, and certainly I think the government is looking in a lot of cases to make that argument, that maybe there might not be actual knowledge or actual participation, but there should be kind of a constructive knowledge in the sense that, this was inherent to the plan or the strategy. Obviously, I think when you have violations where you've got senior management or the condoning actions, that's a whole different situation. I think I've seen less of that in kind of either the research I've done or the work that I've done.
So I'd like to shift gears and touch upon your time in the FTC. Could you speak to some of the major cases that you worked on while at the FTC?
Yeah. So as I said up front, my time at the FTC was kind of divided pretty much in equal halves between a couple years where I was a staff attorney in which was what was first known as the Division of Credit Practices and then became the Division of Financial Practices. And I think now in FTC parlance is known as the Division of Privacy and maybe Identity Theft. I'm not even sure. I think it's privacy. And I was coming into the FTC at a time period where e-commerce was really, as shocking as it may sound, starting to happen. And the fundamental question that industry, Congress, and the FTC was examining was like, what do we all need to do to facilitate, to kind of enable? We think e-commerce is a good thing. We think it can create jobs. We think it would be good for customers, for consumers. But we're also concerned that if it doesn't have the right framework around it, whether those frameworks are existing laws, new laws, or self-regulation, that it could not succeed. So that was kind of the core question at my time. It was kind of a very interesting time to be at the FTC. Kind of saw a lot of early companies, like companies like eBay that were kind of very, very young, or Amazon very young in their infancy, seeing kind of how they were trying to tackle this question. And so I'd say some of the cases that I worked on early on were kind of oriented around privacy and trying to kind of look at what are the existing laws that the FTC has, how can they be enforced. So I worked in a case against one of the credit bureaus called TransUnion under the Fair Credit Reporting Act, which is like one of the first U.S. Privacy laws. And the issue in the case was, it was administrative litigation. I was a very young lawyer. I came in pretty close to the end of the investigation when we're starting to prep for trial. And the issue was TransUnion was reselling certain data from its credit consumer reporting databases to marketers and packaging it in marketing lists and other marketing data. And the question was, is that regulated by the Fair Credit Reporting Act? Was the first question. And the second question was, it was really a defense that was raised by TransUnion was, can the government in an enforcement action, when it's trying to kind of enforce the Fair Credit Reporting Act for the sake of consumer privacy, do we have First Amendment rights to disclose this data because it's commercial speech? And if the government's asserted interest in kind of defending or the government interest that the FTC was advancing was consumer privacy, what's the difference between the data that they have and all the public record data that's available? That was the First Amendment issue. And how can you say that the law is kind of narrowly or materially advancing a government interest in privacy when there's a plethora of public record data that's more invasive available and that's unregulated? So it was a really interesting, first of all, just being thrown into a case and doing depositions and was really interesting. And then the First Amendment issues were really interesting. I mean, the statute was kind of an old statute, but it was really kind of a core question for how much can the government or Congress, should I say, pass laws that regulate in the name of privacy, and how do they navigate the First Amendment concerns around new laws that regulate privacy? So it was kind of a primer on that. The second case, and these are cases that I worked on when I was a line attorney, so I was kind of involved in building the cases. And the second case I worked on was a case called FTC versus Touchstone Information, which was a information broker that was working for private investigators, media agencies, was kind of posing as individuals in order to kind of go to banks and other institutions to get information on other individuals that it would resell. And it was a kind of hot topic in Congress, and it was kind of very unclear whether the FTC Act could be used against this. So it was kind of, I mean, kind of consistent with what we talked about in class, where you've got, an issue that Congress is concerned about, which is information brokers that were kind of fraudulently getting information, but it didn't involve traditional deception in terms of consumer representation to a consumer. So we used a very novel deception theory and a very novel unfairness theory in terms of getting it through the commission. And at the same time, we were involved in congressional testimony about, what this case was and how it might fit into the way the law should evolve in terms. And ultimately, Congress passed a law that specifically addressed this practice, which was called pretesting. I'd say the other kind of really interesting part of this case was in order to kind of gather evidence, we set up sting operation with a group of banks where we fed information requests to the information broker. We had the banks cooperating. They taped the conversations where they were pretexting to getting the information, and we wound on ABC Nightline as a featured story. I wasn't interviewed or anything like that, but it was kind of a fun. It was like a interesting case because I kind of built it from the ground up. I had to really creatively think about the legal theories that we were using. And it was all a case that was kind of done in the middle of kind of an active legislative debate about whether the existing law, where we took a novel theory, was sufficient or we needed a new law. So it was kind of interesting in that way. But those are the two cases that stand out.
And how often, from your experience, would an FTC case be paired with correlative legislation by Congress?
No, I would say that was pretty infrequent. I would say that there was, at the FTC, from my standpoint, there was kind of bread and butter consumer fraud cases that the FTC was going out and doing, which I think everybody, the FTC and Congress, said, we like you doing that. We want you to do more of that. It wasn't something that would generate, kind of a hearing in and of itself. But there were lots of areas. I think that the kind of fact pattern of, do we need a new law? That was relatively rare, but aligning kind of FTC enforcement priorities with what Senate and House oversight committees were interested in was common. Meaning it wasn't that there was a live piece of legislation, but it would be the Hill was saying, it's very important to us, to the oversight committee, that the FTC be active in a particular area. And therefore, we want to understand what you're doing. There were counterexamples where there were certain members that had the opposite view. We say, wait, we don't want you to be doing this much, or we think you're overreaching here. Like dietary supplements was in the mid 90s kind of for certain members of Congress, there was a sense that the FTC was being too aggressive in its enforcement authority and bringing too many actions against dietary supplement provider or even specific dietary supplement providers in certain states. And the FTC would go up and almost have to defend the actions it was taking. So there were kind of lots of different congressional interfaces, but I'd say the Touchstone case was rare in the sense that it was like a live kind of, do we need a new law here discussion. So that's kind of always what made bringing cases interesting, because it was never in a vacuum. It was always somehow or other in a case of, is policy enough? Is the agency doing enough, too little? Should Congress be doing something? Are consumer groups happy? Are industry groups happy? You're kind of always were in the mix of those types of dialogues.
It seems, at least from my standpoint, that debate regarding the authority that administrative agencies should have has increasingly become partisan. And traditionally, Chevron deference has been used to afford administrative agencies a decent chunk of deference. And for the audience who's unaware of what Chevron deference is, essentially, if an agency's statute is ambiguous, then courts generally defer to an agency's reasonable interpretation with regard to legislative rules that they promulgate and decisions that they make. But as we discussed a little bit in class, Chevron deference, it seems that Chevron deference will eventually be overturned on the Supreme Court. So in your mind, what would a world without Chevron look like?
So I'm going to give you the classic lawyer answer. It depends, right? It's interesting in thinking a little bit about this question. I kind of was reading a little bit more about the origin of Chevron. And Chevron, actually, what's interesting about it is it's kind of an 80s case. A lot of what Chevron was kind of in the Reagan period, wanting to be able for courts to restrain agencies to restrain courts, right? Was kind of like the courts are kind of being too liberal in terms of how they interpret certain laws. So we want to put the power back in the agencies so that we can have deregulation in the agencies. And I think that's certainly consistent with what my understanding of the history of the FTC was the 80s was a period where agency and the empowerment of agencies was to deregulate. So I think, it a little bit depends on kind of what the particular agency is and what kinds of things they already do. I mean, I think a lot of agencies are not contending with kind of high flying, difficult, ambiguous policy issues. And I think a lot of people in agencies would say, 95% of the time, what we're doing is kind of pretty squarely within the authority, and there's not a lot of second guessing about, whether we look at it through the lenses of Chevron or major questions. There's not a lot of second guessing about whether what we're doing is consistent with the delegation that we got from Congress. So I think there'll be a chunk of what certain agencies do that is really wouldn't be that impacted by Chevron. So that's kind of it depends what agency we're talking about. I think the other part of this is, okay, the Supreme Court heard a case. The Supreme Court has kind of been signaling for a while that it wants to kind of relook at Chevron and probably overturn it. It's like, well, what does it actually mean? In what way do they overturn it? Do they overturn it in a way that's more about prospective agency decisions? Do they overturn it in a way that opens up kind of retrospectively looking how our statute of limitations applied? So I think kind of the scope of disruption that overturning Chevron, could cause is a little bit dependent about what do we think. I mean, I do think the Supreme Court is not going to leave Chevron alone, but it's like how many ripple effects will that cause? I think one could look at just that question and saying, is it prospective, is it retrospective? Is almost the way I was thinking about it is like, are we just freezing the status quo? Like, we've got a lot of regulation. I mean, compared to the 80s, we've got a lot more regulation. Are we just kind of saying there's not as much more and we're just going to freeze where we are? or are we going to really try to actively undo it? That's kind of a little bit of that, like which way does the Supreme Court decision point? I think inevitably, um, it's going to make agencies, whatever the contours of the decision were, it's going to make agencies think long and hard about how they make the decisions they make in order to try, and maybe that'll make them more closely hew to, or more conservatively hew. And I don't mean conservative politically, but more like we're not going to take as many risks as being perceived as going outside of what the explicit delegation is from Congress. It'll create more detailed kind of analysis to kind of keep themselves consistent with the congressional delegations. I think the other part, and this is probably given our political dynamics, in theory, it could be good. In practice, it's probably not going to be good. I think it's going to put a lot more pressure from the agencies. I mean, this already exists. I think people think that agencies are off running, just doing whatever they want. I think that inevitably there's a lot, particularly with independent agencies that depend on funding from Congress. There's an enormous amount of dialogue between kind of the congressional liaison staff and an agency with their oversight committees to say, here's what we're thinking about doing, or what do you want us to do, or how do we fashion this in order to try not to get, out ahead of what Congress wants an agency to be doing. I think kind of overturning Chevron would create even more pressure on that and kind of more demands from the agency as well as the public to say, no, look, okay, what the courts are saying is this decision is in the political process. It's not in the agency's process. So you have to be really explicit. And that's why I kind of preface that to say, in theory, that sounds good, because if the political process were able to deal with some of the issues, maybe that would be a good thing. But part of the reason I think we've gotten here is we got a complex society that in the best political dynamics, it would be difficult for Congress to spell everything out. In a kind of dysfunctional political process, the idea that they're going to take more on and decide more of the tough calls seems kind of difficult. But those are some of the kind of, I think, potential repercussions that overturning Chevron could have, depending on, variety of fact patterns.
As we touched upon in class, corporate purpose differs regarding which corporation an individual is a part of, and there's numerous different theories which govern corporate purpose, whether it be stakeholder theory, shareholder theory, social contract theory. So in your current capacity as a member of the board of directors of Astellas Pharma, how often do theories such as stakeholder theory, shareholder theory, or social contract theory cross your mind? And in your current role, what is your fiduciary duty?
Yeah, so I would say, and I think I said this in class, and I felt this way when I was in company more on the management side, and I think kind of sitting on the board. I'm not sure that I am sitting there saying, okay, should I apply shareholder theory here or stakeholder theory? I would say I am in all of when I was in management, when I was in board, I am very conscious, I think, of probably what would be stakeholder theory. I'm very, to be honest, for me personally, the shareholders were probably the last set of stakeholders that I thought about. And maybe it was some of the roles that I had. I mean, more often than not, my kind of framework was, okay, how would a decision, this is more on the management side, and then on the board side, it's kind of like the nature of the oversight that we're providing. How would an outside regulator look at how we were analyzing and thinking about and the considerations we were taking into account and evaluating, a strategic decision, a business decision? How would the broader public think about that? How would our employees think about that? And then obviously I think you're not operating in a vacuum. You have to be aware of what are the impacts on the business. But I think kind of integrating, certainly I think even in the business impacts, and again, most of the roles that I was in, either in management or kind of sitting on a board, was trying to take a longer view. So it was less about what are the short-term impacts. You obviously have to be cognizant of those, but what are the kind of longer-term impacts on the business? So I think even though I don't know that I would have labeled it as such, I think I was kind of actively applying stakeholder theory. Um, I think in terms of like the fiduciary duty, um, when I was at Temple, we did a multi-day, I think it was a 2-day conference on Caremark, which I knew about, but got very, familiar with it. And I thought what was interesting about Caremark as a case, and we talked about this in class, I mean, it is a case where it's a liability standard for individual directors, which now as a director, I'm kind of dealing with the, Caremark risk of Caremark-like claims. It's a tough liability standard and in the sense for shareholders to bring a case. That being said, I think for me, it has always seemed broader in terms of, what that fiduciary duty implies. Not necessarily, I guess I'm obviously looking at it not just through kind of the pure litigation risk standpoint. And even then, most directors have directors and officers liability insurance. So if you're acting reasonably, you're likely to be covered. But I think it's similar in terms of the way I looked at the corporate purpose, which is somebody's going to look at how a director behaved through that broader lens of what would all the different stakeholders theory. So I think in some ways I felt like I'm importing stakeholder theory in terms of, how I think about what that fiduciary duty means. And that's in kind of real day-to-day practical terms.
Yeah, it seems to me that corporate purpose is inherently context specific. I know I recently shadowed LGST 1010 guest speaker, Mr. Ryan, and he let me know that when he was CEO of Unilife Corporation, that his corporate purpose was almost entirely shareholder theory, but now as in his current role at Temple Health, because he has no shareholders, it's completely shifted more so to stakeholder theory. So would you agree that corporate purpose is inherently context specific?
Yeah, I think it's context specific. I think it's related. I mean, we talked a little bit about this, I think, when we were talking about the Merck case study, about river blindness. And it's like also personality specific,
Mhm.
right? Like, what is your leadership like? What's motivating them? What's driving them? Um, and how does that inform kind of the decision-making process? I mean, you wonder, in that specific fact pattern, you had like a CEO who had been a research scientist who was very aligned with the kind of the scientific discovery purposes of the corporation. Obviously they were cognizant, he was cognizant, I'm sure, of the shareholder interest, but it's the context and it's the personalities involved and it's kind of the stage of the company. If a company's at a point where it's in, financial distress and really trying to kind of deal with shareholder issues, they're probably going to be thinking more about the shareholders. They're going to move to the front of the line of the stakeholders.
Certainly. And so you also touched a little bit upon Caremark. So just to give the audience a definition, if you're not aware of Caremark, essentially it established a duty to monitor for boards of directors. Directors are required to take affirmative steps to put in place an information reporting system. Significant deference is given to directors regarding the decisions that they take. And liability is established if one, directors failed to provide reasonable oversight in a sustained and systemic fashion, and two, if the information reporting system was an utter failure. So in practice, what do members of board of directors do to ensure that they don't violate Caremark?
Well, I think most of the companies that I've been involved in, either on the management side or the board side, either being on a board or advising people and kind of designing what the board interface or thinking through the board. I mean, the kind of first threshold issue is like, what kind of information is going up to the board? I mean, look, if you don't have a committee at a board that is regularly getting on a quarterly basis or more a set of information that helps the business look at, understand what the risks are in the business, how management is trying to manage those risks. I mean, that's a threshold issue that you have to kind of sit there and say, is it there? Do we think that we're getting what we need? So I think that's kind of that's like a core thing you got to ask right up front. Then the second part is like, okay, when you're starting to get the information, it's kind of starting to probe into what is the information, dig deeper in certain areas. I always feel in kind of fulfilling a Caremark duty, um, that understanding management and management personalities and understanding the dynamics within the business that are going on maybe outside of the board meeting. Because at some level, one of the challenges I think of doing board oversight is there's so much information coming out. So I think you want to really have the ability to kind of without kind of, I think, crossing the line that we talked about, board is not running the company, but trying to understand like what is management dealing with? What are the personalities? How does that shape when I see information? What can I read between the lines, and then pushing where I want to see between the lines of what are the dynamics. And then I think you kind of fundamentally, you got to be diplomatic about it, but I think you have to have a view that I'm going to ask the question that maybe is being asked or wondered about at the management level, and ask the tough questions, like be willing to, like, okay, is an acquisition that we did that we had, high hopes for, is it not working out, and is it creating risks? Is a new product launch that, we set the financial expectations for, is it not playing out and is not creating risk? So kind of being willing to ask the uncomfortable question, while still being, consistent with the process of the way information flows, and not injecting yourself into the business. I'm a big fan of executive sessions with certain key members of management that is kind of outside of the context of the formal presentation through the information reporting system, so that you can, get context around what you're hearing about. And I think you got to be really thoughtful about, one of the challenges, I think, is if you get information overload on risks and information about risks, sometimes you lose the forest through the trees. And I think that's a kind of thing that you have to kind of constantly be revisiting to say, are we getting the right information? Are we getting too much? Are we getting too little?
To me, it seems that Caremark is what I like to term strategically ambiguous to sort of allow for societal change. I mean, when I read it, I always ask myself, duty to monitor what? And as we kind of discussed in class a little bit, there has been debate about whether Caremark should be extended into ESG or into, sexual harassment cases. So how far, in your opinion, do you think that Caremark should be extended? And for example, to use ESG as an example, in your opinion, would it be wrong to extend it into environmental social governance?
I don't think it would be wrong. And so I'm thinking about the different viewpoint, the different perspectives we talked a little bit about in class. Like I think Stephen Bainbridge was someone who thought, one had some critiques of, is a law professor from one of the California schools, who thought Caremark was a little bit wrong in its narrow definition, and then certainly thought it shouldn't be extended. I'm not sure that I'd like to see it extended with this caveat. I think that for me, part of the issue is in order for Caremark oversight to be effective, you've got to deal with this question of how do boards actually kind of get the right information and be able to analyze it. And this kind of concern that I have a little bit about boards getting too much information. And then, when you have too much information, in some ways you don't focus on the right things or any things. So like sometimes with enterprise risk management programs, which are kind of pre-steps to where companies look at all of their risks, I think sometimes what can happen is you kind of throw everything up, and then it's kind of becomes less clear how you kind of narrow and dive in on things. So for me, it's less about what I like to see Caremark be expanded to deal with things like ESG, and it's more like, how do we do it in a way that ensures that we can effectively do oversight and not kind of lose sight of kind of being able to drill down on risks. So it's more of a practicality and feasibility. I don't have a concern. I do think it would be good for boards to be thinking about risk more broadly. I just don't want it to come at the expense of losing kind of the rigor of risk oversight.
So as you touched upon in the beginning of the episode, you made the switch over to academia in 2016. And then just recently, a few years ago, you've come over to Wharton. What is your hope for the future of your career at Wharton? And what has been the most rewarding experience that you have had thus far?
So I think it's interesting. Kind of when I went to Temple, I think my motivation was I was talking about creating a center and bringing together academics, industry, and government, and creating dialogues that I felt like needed to be had. I think what I'm doing or teaching at Wharton has been a little bit different. It's it's undergrads. It's kind of a broader topic. So I think what motivates me, there's two things why I'm doing and what I want to get out of it. One is I think interacting with all of you keeps me on my toes. It kind of keeps kind of the way I feel about like my kids. It's like my kids at the dinner table don't want to hear about the issues that I'm working on, or maybe sometimes they do, sometimes they don't. But I feel like keeping myself intellectually fresh, having my conceptions of how I see things, kind of different perspectives, either generational, geographically, to challenge that or make me think about things differently. I think that's one thing that I really want out of teaching it at Penn or at Wharton. I think the other part is the most satisfying part for me is talking with a student. And I think, as you can tell from my career path, I've moved around a lot in ways that if you asked me if this is what I would have done when I was 19 or 20, I would have no idea. I would not have said that. Most of the people I know, their career paths have been that. And I think the most important things or most important influences on my career path and on the people that I know is the people that they meet along the way. And so I think if kind of being able to try to help a student and not in a prescriptive way, but in a way that is just kind of helping them think through, exposing them to new issues, new kind of pathways, helping kind of get them thinking about it or getting new experiencing. I think that's the most satisfying thing. And if I could kind of have this phase of my career of teaching kind of have students that go out into the world and do interesting things, and I've helped them kind of get some of those experience along the way or think about things that they didn't think about when they started their education, that would be very satisfying. So that's kind of what motivates me.
And like me, many of the students in LGST 1010, I got the feel were considering pursuing a career in the law. And I know that that's something that could be quite difficult to navigate, especially as a freshman or sophomore in college. So what would be your advice to students who are interested in pursuing a career in law?
I think try to get, whether it's through work experience, discussions like this, doing something like, you did, shadowing someone for a day. Don't assume that first of all, I think what you can do with law, there's so many different permutations of what you can do with law. So getting as much exposure to those different kind of career pathways, and kind of understanding, what day to day can be like, as well as, where that can take you, and being really open-minded about it and not assuming the answer to it. I think that would be, my best advice. I mean, I think that's part of with law and social values, why I try to bring in people who have kind of diverse career experiences and have kind of long runways where they've done a bunch of different things, is to say, I'm not sure what your understanding of what it is to be a law, what law is or where it can take you, but here are the variety, and this is just a small sample of the kinds of things. So just kind of getting that exposure wherever it takes you. And then also kind of like allowing yourself, if there's something that, I find in my own career, there were certain things that I did, which I thought were going to be a certain way, and I ended up not enjoying them, or it wasn't what I thought it was going to be. And that's okay. And in law, that's, don't get discouraged by that, get informed by that. and take some of those chances and don't get discouraged. I think that would be my advice.
And I could definitely add, just from my experience, taking LGST 1010 is a great first step, because I know obviously I'm only a freshman and I've only been here for a year, but this was a class where I was really able to experience the law in a way that I couldn't imagine outside of potentially going to law school. So I was so very fortunate to have Professor Smollen as a professor this semester.
Well, thank you. I appreciate that. And I appreciate being able to be here with you today.
Yes, thank you for coming on the podcast. It's been an absolute pleasure today. As I said in the intro, this is the first episode of Meet Penn's Professors. We hope to keep this going for many years on end, and I'm just so grateful for you to come on the podcast today.
Thanks.